Today, there's been a court case that's both personal and political. It's about a man who, for all his privilege of birth, has found himself marooned in the cold periphery of the very institution that raised him. Prince Harry, the Duke of Sussex, is returned to the UK this week, not for ceremony, not for reconciliation, not to see his father, His Majesty the King, as he jets off to Italy, but to fight in court for the right to feel safe on British soil. This isn't a celebrity tantrum or some royal grievance tourism, as some tabloids might prefer to frame it. It is, at its core, a legal and moral challenge to how the British state, via the Home Office, ruled at the time by either Priti Patel or Suella Braverman, has treated one of its own with what can only be described as institutional contempt. In 2020, after stepping back from royal duties, Prince Harry and his wife Meghan ceased to be working royals. The result, the Royal and VIP Executive Committee, RAVEC, decided that they would no longer receive automatic taxpayer-funded protection while in the UK. Notably, this committee operates under the auspices of the Home Office, which at the time was helmed by Priti Patel, later by Suella Braverman, neither of whom are widely remembered for their nuance, compassion, or deft handling of complex matters. In fact, what they do is tell people who are in the UK without very clear definition that they should stay in a hotel for an indefinite period of time, and tell everyone else that it's a five-star hotel. But actually, isn't that what Harry did? Hasn't Harry been staying in hotels when he's come to the UK? No, Harry has returned to the London's Court of Appeal, arguing that RAVEC failed to follow its own procedures, specifically that no assessment was made by the Risk Management Board, a body whose role is expressly to evaluate threats and inform decisions on security. Instead, the committee created a bespoke process, ad hoc, untransparent, and without consultation, and Harry's barrister, Shahid Fatima KC, rightly describes this as unjustified and inferior treatment. Now, Harry's not claiming special privilege. He's not asking for the red carpets or palatial escorts. He's asking for the application of rules consistently, fairly, and professionally. And what's at stake here is not merely personal safety, it's institutional accountability. Harry's status may have changed, but his visibility and the threats against him have not. He is still a royal, still fifth in line to the sun, still, and this is significant, the son of the monarch. The fact that Al-Qaeda has reportedly called for his assassination, or that he and Meghan were involved in a harrowing paparazzi chase in New York last year, or the year before, is hardly irrelevant. Yet under the current arrangement, Harry must give 28 days' notice before visiting the UK. His security is assessed per visit. Not only does this system create a dangerous vacuum, it suggests a logic whereby risk only exists at scheduled intervals. A terrorist or a stalker, presumably, must consult the Home Office calendar before acting. And the argument from the Home Office that Harry's circumstances don't warrant inclusion in the usual security cohort is both obtuse and chillingly bureaucratic. It's a computer says no mentality disguised as judgment, as if institutional spite had acquired its own filing cabinet. And let's not forget the political culture in which this was made. The Home Office under Priti Patel and Suella Braverman became a factory of hostility, whether towards migrants, asylum seekers, or indeed wayward royals. Vindictiveness, not governance, has been the watchword for the Home Office. What else could you expect from a department that viewed refugees as criminals and lawyers as lefty do-gooders? The notion that a ministerial team with so little regard for human dignity could make an impartial, generous judgment towards Harry, who had by then become a global voice on trauma, racism, and institutional failure, is laughable. The decision to strip him of royal routine protection wasn't just a bureaucratic misjudgment, it was a message, and it sounded very much like, you've embarrassed us, now you can fend for yourself. We shouldn't forget the image of a boy walking beside or behind his mother's coffin, age 12, that same boy who now says, I cannot put my wife in danger, nor myself. How many times must that trauma be repackaged and relived for us to acknowledge the reality of his concerns? Harry isn't asking for indulgence, he's asking for procedure. And if the law cannot assure that basic safety of one of the most recognisable public figures in the world, it must ask, for whom then does it serve? The case is more than an appeal against procedural failure. It's an indictment of a Home Office that too often prioritises politics over principle. It's a plea for consistency in the administration of risk and security, and yes, it's a reminder that even princes can be scapegoated by the very machinery that once served to protect them. Prince Harry may not get the ruling he seeks, but in fighting this case he is forcing the country to confront the quiet cruelty of its institutions and the brittleness of the promises they make.